Hello everyone, it's Anthony Thorpe again making another insert in a series based on targeting the corruption that's going on in not only government but the courts in Jamaica and the repercussions from the corruption that is going on, and it's serious. So today is April 12th, 2023, and it's 1:09 p.m. It's pretty cool today, kind of overcast in Florida, but still a nice day. Rains aren't coming yet, but when it does come, it cools the place, so that's good for us. But getting right into it, so I informed you before that I was in the motion of getting information to each of these agencies that are connected or this ruling from the appeals court affects. And just a reminder to those of you who have not heard about the ruling and the impact that it will have or the effect, I'm going to kind of detail it for you a little from now, but in a gist and condensing it as quickly as possible. What happened? The Supreme Court in 2017 under Justice Tai ruled that real estate developers, even if they were registered legally with the real estate board, were operating illegally, and any agreements they entered into or any developments they did, pretty much anything having to do with real estate that they transacted from the Real Estate Act came into being, was illegal. Any agreements were illegal, illegalities, and contracts were illegal because they did not have a real estate dealer's license. Now, of course, the law was before, or as was interpreted not only by the government but by the real estate board that regulates real estate developers and real estate dealers. It was only required for the real estate developer to be recorded or registered with the real estate board. There was no licenses or anything. So, of course, when we filed a lawsuit against one of our joint venture partners who wanted to jump ship, and did jump ship after we spent millions of dollars and signing a contract that was binding upon signing, we had filed a suit to enforce the agreement. And what Justice Tai ruled on was, when she looked at the law, interpreted the law, what she was saying, the law was saying the contracts or the agreements, the joint venture agreement, couldn't be enforced because before a developer can enter any kind of agreement, including a joint venture agreement, they needed to have a real estate dealer's license because they were in fact transacting real estate business. That's ludicrous, of course, but that's what the ruling was. And so we sent it over to the appeals court, and after years, the ruling just came on March 31st, 2023. So from 2017 till now, that's almost 5-6 years roughly, or approaching 6 years. We've been waiting, and finally when it came in from the appeals court agreed with Justice Tai. Now, I submit that the judges who made this ruling knew better, but because I have been so vocal about protecting my legal rights and interests, both in terms of our business and the law and my partners, I have a fiduciary responsibility to protect my partners and investors. So I've been doing that. I've been screaming like a pig that's been stuck. To let the world know I'm not going to sit down and allow any corrupt judge or any corrupt system that's bankrupt to steal from us, because that's what they were doing. So by delaying cases, by making bad rulings and deliberately making bad rulings in order for the matter to either be appealed or stuck in the system, which is what they've been doing. So it's a strategy that they've been employing, and a lot of the attorneys that they link with that use these corrupt judges, that's what they do. Put your stuff in the courts and have it dragged out for decades. We have matters in the courts that's been filed since 2007. In some cases, we are due a default judgment because the people didn't file a defense. So under the law, it's mandatory that once a default judgment is due and an application is made for that, then the registrar is supposed to sign it. But they've been filing all kind of excuse not to do it. So we have had matters sitting in the courts and losing economic advantages that we had, because I was introducing to the Jamaica market major real estate developments, mixed-use real estate developments, which was not yet being done in Jamaica. And so we've lost that advantage, because currently in Montego Bay alone, I think there are about 5 or 6 major projects with high-rises reaching 28 stories, I'm told, that have been approved, going through the building process. And our developments that's been approved since 2008 and 2007 are still stuck because of the corruption in the court. So, and it shouldn't matter whether judges like me or not. That's unimportant. You have a job, do it, and stick to the objectivity of what you're supposed to do in order for the system to work. And so this ruling that came down, that was grossly in conflict with the existing law practiced by the government and the real estate board that regulates real estate developers, was done deliberately to mess with us, pretty much. And so, as I said yesterday that, and the day before that, I'm going to keep you up to date as to what we're doing, in order so you are aware of the kind of things we have come up against in just trying to go about our business and in a legal, legitimate way. And yet we've been stuck with these people finding every which way to damage our business, to damage us financially and otherwise. So I told you yesterday that I was waiting on responses from certain government agencies, including the real estate board itself, and I haven't gotten any yet. I tried calling them this morning, but the phone just rang, either rang, or when they rang for a while, they'll just be cut off. I finally got through on one line and left a message for Mr. Brown, who is Cresfroid, Cresfroid Brown, the Chief Executive CEO Officer, in short, acting CEO. So left an extensive message on there for him to get in touch and respond to the information and the documents that we've been sending to see how are they going to fix this matter. Because as I said to everybody, I'm not going to spend or waste my life appealing this, because that's their game. I'm going to put it out there and let them fix it, because they have to fix it. Because if they don't, then it means homeowners who bought homes from any developer, and it doesn't matter who, whether it's NHT or an independent developer, anybody who purchased homes from them, if when a research is done and the real estate board cannot produce any kind of documentation that they were registered as a developer along with a license as a real estate dealer, then those developments, all contracts, all agreements are illegal and unenforceable. And then there's a reciprocal effect of any mortgage agreements, any agreements whatsoever, whether it's a third party, fourth party, generational, down the line, are illegal agreements. So the effects are that any agreement that you entered to are illegal, and therefore you deserve relief from it. So, and the way it's written now, and I've read it and looked at it and the processes in the court, we're not appealing it, so there's nobody else to appeal it, and the court technically can't review its own decisions. And this matter was ruled on by the Supreme Court and the Appeals Court, and the only other court it could go to is the Privy Council. And unless we file an appeal to the Privy Council, there's nobody else to appeal it, which means the Privy Council would not have jurisdiction to review a matter if the litigant who lost the case does not appeal it. And if other developers should go ahead and file a claim trying to overturn this. The reason I mentioned that the court cannot review its own ruling or review its own decision is simply that we filed as developers that were legally registered according to the practice and according to the real estate board, paid our fees or all of that stuff. In fact, they have developments in front at the real estate board that we've paid up all our fees. The only thing that's there is one of our joint venture partners was to remove a caveat from the property, and that's in front of the court now. We're waiting on them to fix it. However, so we were legitimately registered as real estate developers, but in order to get at us, these judges went in there, ignored all of that, including Justice Ty, and ruled that we needed a real estate dealer's license. As I said, they just did it to throw a monkey wrench in the system, because as I've always said, I don't think any dummies are on the board or any member of the judiciary are dummies. And when you read the law and the construction of the law, the Real Estate Dealers Act, there's clearly no confusion as to what was required of us. And the other thing, as I've said, if you were confused as a judge and you read the thing and it wasn't straightforward enough, then just pick up the phone and call the real estate board and find out what's going on. And the reality is that none of them did that because they didn't want to. They didn't want to rule on this fairly or so that we could go on with our business. It's just being vindictive, and that's what it amounts to. And that's the kind of corruption that the global market and regulators all over the world have been identifying, that the level of corruption in Jamaica is so rampant and common that everybody knows it's happening, but they do it because nobody is holding them accountable. And so our goal is to hold them accountable, because you don't take money out of your pocket and just sit down on a bench and think it's okay. You're robbing people, and that's what you're doing to me and my partners. And you sit there, and because you say you're a judge and this independence of thought does not give a judge the right or the authority to cheat people out of what's theirs. And as I've said, the court claims it's an agency of equity, of equitable remedies. Which equitable remedy could be looked at, and a judge comes up with the idea to just blanketly say that Mrs. King didn't violate any agreements because the agreements were unenforceable because we entered an agreement illegally, when under the law that's not the case. So our thing is, if you burn us, then you have to burn all them other developers. Not care how them big, whether they're run by government or not. You must apply the same principles to them as was applied to us. So every homeowner that purchased property from any one of these developers are being given notice that if you want to make money and save money and put this country in a position where corrupt people will be held accountable for their deliberate attitudes and deliberate acts against other people or citizens of this country to destroy them and cheat them out of what's their property, then this is an opportunity that you could use to do just that. So by exercising or enforcing the judgment which protects your property or gives you property under the judgment and keep your money in your pocket, then you should take advantage of it. And so we made certain recommendations. So without dragging it on, one of the first things we did when the judgment came down, we said, all right, let's get in touch with the regulator, the real estate board itself. So we sent a notice to the real estate board from the very first time we got the judgment. And I'm going to read it a little to you so you understand that anything you're hearing here is what the real estate board has. And we haven't heard anything from them, and this is the regulator. And we CC'd it to various entities, including financial institutions, and they've been pretty quiet as well. We also sent them information again this morning, and we sent information to organizations that represent workers, whether civil servants, nurses, teachers, policemen. We sent information to hopefully the relevant parties, and when they get it, they won't bury it. I don't see why they should, because we said to them plainly that this benefits your members, and if you have your members' interest at heart, then you need to take a serious look at this, because you could help them to save a lot of money that would be beneficial to them and their families. So we sent this letter or notice to the real estate board, and it starts out by saying we have a list of the executives up top. Then the first one is Mr. Philip Chambers, Chief Executive Officer. Then Mr. Crestfroid Brown, Chief Executive Officer, Operations Officer, Acting. Then we have Inspectorate Real Estate Board, Akil Plaidley. Manager Inspector, Acting, Patrick Clough, Clough, Senior Inspector, and it goes on, Inspector Development Schemes in the next column, Anne-Marie Henry Lewis, Horace Nora, Inspector Investigations, Natasha Good, Senior Secretary, I hope it's pronounced properly, Goode, Good maybe, and we have a timeshare, Ainsworth Norton, Manager. And it goes on to say, from Anthony Tharp to the executive body of the Real Estate Board, re-ruling of the Jamaica Supreme Court, which was affirmed by the Appeals Court of Jamaica. Dear sirs, and when you're writing letters, there's this bias about dear sirs. I should have put madam too, but without being prejudiced or feminist, I put dear sirs. So apologies to any of the women on the address block here. Dear sirs or madam, in late 2017, Mrs. Justice Tai ruled that real estate developers who did not hold a real estate dealer's license was operating illegally, and more significant was the statement that any contracts entered, and I mean any contract in brackets, were illegal contracts and could not be enforced. That's a judgment. On the 31st of March 2023, the Jamaica Appeals Court affirmed Justice Tai's judgment, meaning, if you're not familiar with the legal term affirm, it simply means the Appeals Court agreed with Justice Tai. So on the 31st of March 2023, the Jamaica Appeals Court affirmed Justice Tai's judgment. Thus, 1. All agreements entered by a real estate developer, regardless of whether the developer was legally registered with the real estate board or not, was operating illegally. It means that anyone or persons or party that acquired a home or property from these real estate developers had also engaged in an illegal activity. It also means that all agreements coming out of this relationship with the real estate developer that was not registered, was not holding a real estate dealer's license, were illegal and unenforceable. And I said earlier that it also means anyone or party acquiring a home or property from these real estate developers had also engaged in an illegal activity. So in short, if the contractor or the developer was operating illegally and you went and bought something from them and entered agreement with them while they're carrying out illegal acts, then it means as a homeowner, the purchaser, though you did not know this, you were also engaged in an illegal activity. For example, if somebody steals somebody's car, go change the papers, carry it over to you, sell it. You didn't know that they stole people's car and changed the papers on the car, the registration and stuff. They advertise it, sold it to you, have it. Police stop you one day, and when they check the vehicle and realize that something is off here, realize the car was stolen, then you who purchased it from the thief will be going to jail. Simple as that. you're receiving stolen goods. And unfortunately, the law does not discriminate. There's a saying, ignorance of the law is no excuse. So what the ruling is saying is that you're also operating criminally if you purchase home from a real estate developer that did not have a dealer's license. So you should know how that makes anybody feel, that a group of people, a handful of people sit down and then change the law and call everybody criminals. And 4, which therefore means that every mortgage bank or funding bodies where loans were had by purchases of these units from the developer were now void and unenforceable because the original agreement and contracts were illegal. I think that's plain enough. Your loan and your mortgages are illegal, and nobody can force you to engage in illegal activity. In short, it also means that because the real estate developer was not legally operating, then that real estate developer had in fact constructed homes illegally and then proceeded to sell those illegally built homes. So even the concept of the home being built by this illegally operating developer was an illegal activity. Building the home was an illegal activity. It means that banks and lenders cannot legally continue to collect payments for those loans from buyers who acquired those loans illegally, since the illegality of the developer was now in question and was in actuality illegal based on the ruling of the Supreme Court and now the Appeals Court. In other words, home buyers could not be forced to make any loan payments on an illegal agreement procured through illegalities of all the participants in the transaction, original or not. Banks could not try to sue developers. Banks could now try to sue developers and homeowners. However, since the original contracts as well as the operations of the developer were illegal based on the ruling of this court, banks could now try to sue developers and home buyers. However, since the original contracts as well as the operations of the developer were illegal based on this ruling, no court can enforce an illegal contract. So, in other words, the banks are likely to collapse or at least experience significant losses. So if you have investment in these banks, stocks and bonds and all of that, and you check them out and you find out which bank is going through a lot of this or had a lot of mortgages, especially with loaner agencies who gave loans to people with NHT and all of that, be aware that these banks could suffer tremendous losses and may even collapse. So if you have investments, maybe it's a good time to review your portfolio and decide on what you want to do. Securities and investment industry and markets will suffer significant losses, wiping out investors who invest in banks and other real estate development entities. This means insurance companies cannot be forced to honor any insurance policy purchased by the homeowner or property owner who bought the illegally constructed home from the illegally operating real estate developer. It also means that because the illegal violation carries a criminal penalty under the judgment, then every real estate developer that does not have a real estate dealer's license are in fact criminally operating. In short, it also means that homeowners who bought these properties constructed by the illegally operating real estate developer who is illegally operating because she does not have or hold a real estate dealer's license, that home purchaser is also now engaged in criminal activity regardless of whether it was an unwilling relationship or not. This ruling obviously instantaneously will destroy the real estate construction industry and authority of the real estate board, because the ruling/judgment does in fact rewrite or amend the Real Estate Dealers and Developers Act by now making it mandatory for real estate developers to have a real estate dealer's license. The judgment and the ruling does raise several other issues, such as the constitutionality of the ruling in the first place, mainly because in Jamaica, judges or the courts are constitutionally unable to write laws. That's the act of Parliament. However, the dilemma now being experienced or now exists, that the precedent has been set by this ruling, where Justice Tai and a full sitting of the appeals court has now rewrote the laws without it going to Parliament, and therefore the precedent has been set. I am communicating this information to you and our responsible officers of the real estate board so that you can address and take the necessary actions to remedy. I believe the first action the board must take is to make a public declaration that the judges ruled in contradiction of the law, as well as the policy that has been enacted by the real estate board since its inception or creation by Parliament. The board must also immediately find ways to overturn this ruling immediately while enforcing the legal policy previously used to register real estate developers. And do I use the term overturn? Based on my understanding of the law and the rules of the court, it can't be overturned if we don't appeal it to a higher court, and that higher court then decides the ruling was flawed. And we're not appealing it, as I said. Not yet, anyway. And if we are going to appeal it, it's not by us. We're going to make other people take advantage of it and appeal it. However, based on the ruling, again, I would not see how the ruling could be overturned if we don't appeal it. And which means the new law, is in effect and will stay in effect, and therefore will offer every purchaser of homes from these developers a permanent solution that cannot be overturned, and therefore they could make money long term by not paying money to these lenders or developers. Let the government work it out. I have attached the judgment so your attorneys can review with immediate effect. However, you should be able to access directly from the appeals court site. The matter is COA 64 of 2018 or Carif Limited versus Valerine King. I would also like for a formal document to be sent to me and possibly other real estate developers as to how we are to proceed if one wants to develop properties for sale or leasing on the open market. This is necessary since I have multiple developments going through various processes towards getting statutory approval from the relevant government agencies. And I put looking for an early response. Respectfully, Anthony Tharp. So the real estate board can't say they didn't know about anything, they didn't get the information. I've done it, I've sent it on several occasions, I've CC'd other parties, and I've just given it to you so you know, as you know I like to do, is provide you with the evidence and the documentation to say whatever I'm saying to you, you could repeat it to somebody else because you know it's factual. And I sent that to the real estate board this morning, and I sent it along with notices such as this one, because I also prepared a notice which I sent to workers organizations like trade unions, the police unions, teachers unions, and the nurses unions, those that I've had. So they have it, and what they do with it now to help their members navigate through these difficult times and the economy is up to them. I hope I'm doing it because I wanted to reach those members. Now I've asked my partners on the ground in Jamaica to see if they could locate the presidents or the management team of the homeowners associations from these major developments, housing schemes, so that they could have the thing directly in their hands, so they could take the necessary actions to protect themselves or take advantage of the ruling It's presenting some challenges. So I'm asking any persons that's listening here that knows of anybody living in any of these major housing developments to simply ask them for the contact information of these parties, the homeowners association or citizens association, and if you could just put it in the comment section, I'd appreciate it, because I want to get this out as early as possible so that we could resolve the matters as early as possible, because I have quite a few projects on the ground or in the making or in the conceptual stage that are really designed to help the Jamaican economy and people grow and strengthen the economy. And it's rulings like these by corrupt judges who simply don't believe that they should take the time to make the right decision, because if they throw you in the monkey in the system and drag it out, you're being hurt, and they figure it's hurting me and not the entire country, which is what this is doing. And I'm going through this to let you know, and that's what I mentioned in the document to the real estate board, that the ruling potentially has the effect of causing banks to collapse, causing people to lose their investments, rewriting how the real estate industry works. And if it's going to complicate how developers put their money into the market, then you might just have those dollars going elsewhere, which is likely. Because if I'm going to continue to have all this headache going, we just write off the loss and move the money to someplace else that wants it. And it's as simple as that. For now, we believe if government acts fast enough, then we should have a dramatic turnaround in cleaning the courts and getting these projects off the ground and running to the benefit of the entire nation. So we sent out an additional notice which we tagged or attached to the email we sent to the real estate board, and it reads: to all persons and organizations representing workers who may have purchased homes from a real estate developer, including the National Housing Trust. So the National Housing Trust is a developer as well. They develop homes and they sell it. So they are actually a developer as well. And I don't think they have any real estate dealer's license, as far as I know. So they are operating illegally, which brings into question those monies they're collecting from workers. Is it legal collections? Because if you're not, according to Justice Type, any agreement you enter or planning to enter into as a real estate developer, you must have had a real estate dealer's license before. I mean, she even spent a lot of time going over the joint venture, that before you can enter the joint venture agreement, you needed a license. Now, I was shocked for the simple reason that the man on the street walk about any day and enter an agreement with anybody they want about property and land and whether they want to do a partnership. There are no laws requiring it. But what she did, or what they did, was saying, yeah, if you're going to develop property and you say you're a real estate developer or not, then you're required to have this real estate dealer's license. And so where's the discrimination? So the little guy or the man on the street who sees Jack over there put up a sign on his property for sale, and Jack walks over to Mr. Jones and says, Mr. Jones, you're selling the property for 15 million. Guess what? I want to do a development, but maybe it would be better for all of us, rather than you sitting around and having the property sit on the market for 10-15 years, if we come to an agreement and we sign that agreement where you allow me to develop the property, I'll pay you the value of the property and even give you a couple of units in there or share my profits with you. What they're saying is that before you can even do that, you need a real estate dealer's license, which makes no intellectually stable argument when it comes to the ruling, because that makes no sense. There are no laws which could restrict you as a free person going over and making an arrangement with Mr. Jones and his land. That's between you and Mr. Jones. And then if you decide to develop the property with the joint venture agreement and you come up with your plans, then you go, when you're ready to sell your project, you go to the real estate board and you register it. That's what the law stated, but they changed it. So the ordinary man on the street is also affected by this, and it means any one of these regulators can enforce it because it's an illegal act. which means if some policemen decide they want to give you a headache and they find out that you're doing a development or you're planning on buying property from Mr. Jones to do a development, and that vindictive policeman can charge you for a crime. Okay, it's a crime. That's a silliness. Alright, so, and I have in brackets here an opportunity, or in a box, an opportunity that allows you or your membership of workers, it should be workers, yeah, organizations to gain significant financial benefits legally. So I wanted you to see it. So I wanted to see exactly what I sent to these people, that is documented, it's detailed. There's no guessing about what's going on. There's no guessing about what we want or our intentions. And if they mean to protect this island's economy, whether it's the banking sector, the mortgage sector, the real estate sector in general, then they need to act. And if they don't, then we're going to persist, and we're still going to do our developments, and we're going to see who's going to drag us into jail for developing our own property. We're really going to look to see, you know, because at this point, after 15, 20 years literally of having your properties and your project sitting, and some dummy is going to sit on a bench and tell you can't do your project because they feel they're going to change the law, just randomly change the law, and you have to be bounded by it. No. That's like telling me you're going to put me on a plantation, and because I say you're a slave, I'm going to accept that position. No, my ancestors never did, and I will never. I don't know how so many people accept that kind of thing, because if the ruling is unjust, I don't have to obey it. If you're going to take my rights, my property rights, my under the Constitution, guess what? The Constitution says you can't enforce it against me. So we're going to do our developments. We're just clearing the table of some other nonsense. We gave the courts the time to clean up their own business, and we gave the court the time because we wanted to operate in a civilized environment where when people sign agreements, they stick to it. That's all. But here you enter an agreement, and some judge who knows nothing about business, knows nothing about real estate, knows nothing about, profit and loss, going to sit down and just randomly tell people they have to walk away and leave their money. No, not going to happen. Get that to your head. Not going to happen. Alright, so this is a notice to everyone who bought homes and other property from a real estate developer that or whom did not have a real estate dealer's license at the time they sold you your home. If they did not, then you could be one of the beneficiaries of the March 31st, 2023 court ruling by the Jamaica Appeals Court. The ruling gave rise directly and indirectly to the following. All current as well as past contracts signed and entered into by the real estate developer were and are illegal contracts. These contracts are not enforceable under the law. There is therefore no breach of contract if anyone entered an agreement or contract to purchase or develop or manage real estate with a real estate developer who did not possess or own a real estate dealer's license. Technically, agreements, including your loan agreements to purchase the property, would also be an illegal agreement, because the very first financial agreement are a direct result of the first illegal agreement and relationship that also created an illegal relationship between the home purchaser, the real estate developer, who did not have a real estate dealer's license. Then none of the financial agreements, including your mortgage contracts, are legal, and therefore they are not enforceable. This means any money transaction between the lender and the banks and the home purchaser or the developer, directly or indirectly, are also illegal activity, simply because the first agreements were illegal agreements and are therefore unenforceable. No monthly payments can therefore be collected from the homeowner or the property owner by banks, developers, or even NHT, National Housing Trust, to service those illegal financial agreements and loans. Payments or deductions being made by property owners who sign an illegal contract or agreement are therefore illegal as well. And that's 8, 9, Anyone who paid money towards any of these illegal agreements to any party, including the NHT, are due a refund with interest for all monies paid to these parties. In short, if the people collected your money illegally, when you stand up in court or elsewhere, you can demand that they refund your money with interest. Now, knowing how these judges operate, they might just go in and say, well, they collected the money and it's so long ago that they don't pay you back. I could understand a developer who probably will declare bankruptcy, but financial institutions who have been profiting off people, and NHT who was sitting on billions and billions of dollars that the government is always borrowing to go do other things, should get their money back with interest. Because if you can find money to lend government to go do all kind of developments and other government activity that has nothing to do with housing, then you should be able to take the same amount of money or take the money out and pay back people their deductions that you took. Because as a developer, you did not have any license to collect money from these persons, and as a developer, you can only collect money once the property is at a certain stage, and the real estate board has to agree to any kind of escrow account that you're going to set up to collect these monies. Did you have escrow accounts on approval from the real estate board, Mr. NHT, or any of these banks? I doubt it. So again, if you're going to rule against us in that way and try to steal our rights and think just telling us that we're going to sit down and forget it and everybody's operating with impunity, then you're making a big mistake. And any judge that thinking about making rulings like this need to rethink, because this might be the first, but it won't be the last that we take action to stop this nonsense. And I say, if you don't understand your role as a judge, then go into private practice or go retire. But you can't be in here screwing with people's lives, messing up the country, messing up with opportunities, and causing chaos in the country, because that's what you're doing. And I make no apology, because if you don't know what you're doing, just come out of the place, because you don't have any right to mess with people's lives. Being a judge does not give you that right. There are laws and there are rules that you have to follow like everybody else. And any decision like this, you should have gone and picked up the phone and called the real estate board. Go to the Constitution and look under the Limitations Act. Go under the Constitution and look under the fundamental rights and freedoms of people, or the Charter of Fundamental Rights and Freedom of the Jamaican people, and then property and the right they have with their property. And that you can't, regardless of under the color law, you can't go in there and make those changes. The Constitution does not give you that kind of authority and power over people and then property. So know what you're doing. And that's why I say you need to go do refreshers courses or do courses, because you apparently aren't doing what you're supposed to be doing. Okay, wrong number. Alright, so for homeowners who fall into a similar situation with their lender banks or even the developer from which they purchase their homes, then they would technically be eligible to immediately stop paying any loans or mortgage payments, and by law must end the illegal relationship caused by an illegal contract or agreement, because the real estate developer was operating illegally when they signed or entered the first original agreement with you and other property or home. If you or anyone who knows, if you or anyone whom you know are victims of the illegality or the illegally operating developer, then you are eligible to significant financial relief by not continuing the payment of any mortgage loans or notes or from your lender or bank with immediate effect that comes out of a relationship with this illegally operating developer. If you are a victim of the illegally operating real estate developer, then you should not be scared or hesitate, or should immediately contact your financial institution and formally let them know in writing that the judgment of the appeals court made it illegal for you to make these payments, and therefore you will no longer be bound legally by an unenforceable contract or agreement in keeping with the ruling of the appeals court. Refer your lender to the written judgment of the appeals court website, where the judgment can be found under the menu item called Judgments. So it's the appeals court, and look for their judgments, their website. The case number is COA 64 of 2018 between Karif Limited and Valrine King. You should take advantage of this once in a lifetime money saving and asset building opportunity. Hesitance is your greatest enemy to the significant economic advantages as well as opportunities you have now gained. It's all in your hands, no one else. See YouTube channel videos detailing the ruling at Scamming Billions in Jamaica 6208, produced by Anthony Tharp, for your benefit. Recommended strategy for organizations, individuals who fall within the effects of this judgment, making real estate developers without a real estate dealer's license illegal operators. For individuals, it is suggested that they send a notice to their financial institutions and the NHT regarding withholding payment. It becomes the responsibility of the bank and NHT to resolve the matter with government, since government must through legislation solve the problems. Because there is no appeal of the ruling by the only party that could appeal, then that ruling cannot be overturned. By not overturning that ruling, it means the ruling will stand or will be in effect permanently. No new legislation could reverse the effects of the ruling on the current law or make or undo the fact that the effects of the appeals court ruling as being retroactive to the passing or imposition and enforcement or coming into effect of the current law ruled on by the appeals court of Jamaica. In short, even if legislation was to pass to correct or simplify the description of the law, that wouldn't be made retroactive, or it shouldn't be made retroactive to the time when the real estate board came into effect. So everything that you engaged in during that period between the ruling of the court, enactment of the law, and a new legislative framework that changes the definition of the law or corrects it, then the effects of that new parliamentary bill would take effect when that bill is passed and would not apply to anything that went on before. In short, whatever agreement you entered into before would still be illegal and would still have the effects, because in short, I believe they'd have to write off your whole business transaction with those persons, because everything they did, including the developers, were illegal. In any event, because both the appeals court and the Supreme Court already ruled on the legality of the Real Estate Dealers Act as it relates directly to developers, none of these courts could legally rehear a matter already heard and judged. No court can review its own ruling, hence the coming into effect as to what is known as res judicata, and that's a principle of law that prevents the same matter between the same parties that has already been judged from being reheard by the court, the same court. So, no new claim by a developer could be filed in an attempt to reverse the judgment. Because this ruling affect all real estate developers, and the original case was filed by a real estate developer, therefore representing all parties in a similar situation as it relates to the law, all developers by default were a part of the claim ruled on by the Supreme Court and the Appeals Court, as well as the fact that the reading of the judgment and its effects were not confined to the original claimant, Karif Limited, but all developers. In short, by default, all developers have been affected by this ruling. The developers. So, no new filing or claim on the same issues can be made or heard as a matter of law. So don't let them go in there and try to sneak it in there on you, because by law they can't. So let your attorneys know you have an idea about the law, and this is what the law says. So make them write it in anything they're putting in front of the court and fight it along that path. Now, as I've always said, I pray you can find a good attorney that you can trust, that some of them will sell you out. The current judgment, and in fact, I did something I told you in previous video I hate to do, but I did it this time to ensure that you have at least legal argument to stand up on. And it goes on to say, see the matter of Bartholomew Brown and Bridget Brown versus Jamaica National Building Society, ruled on by the appeals court and led by Mrs. Justice Phillips. That's a ruling where the court says basically a matter that's been already judged cannot be reheard by the same court, and that's the appeals court. And any ruling by the appeals court must be by law enforced by the Supreme Court. So if somebody tries to run back there and refile the same thing, then the rules of the court prevent that from happening. Me saying that doesn't mean it doesn't happen, because we have matters in the court that are just like that. We won the case, the person ran back, refiled the same thing, change the name of the employer to the employee, same company, mind you, and it's still in the court. And okay, we raise it with the judges, they're playing games as if we are dummies and we don't know better. But here's a ruling from this appeals court itself that states that, and believe it or not, a matter went over to the appeals court that came up, and part of the basis for challenging that was the same ruling here, and they reserved the matter and sent it back to the Supreme Court for, I guess, trial. I don't know what they're going to try, because you already won the case, but that's the kind of game they play over there. Why? Because they're claiming, oh, it's a new matter because you file it in somebody else's name. That's not what the law says. The law says as long as it's dealing with the same issues. So if you find 10 people change their name and come and refile the same thing with the same issues and the court already ruled on it, then the court is bound by whatever ruling came out of it. But we're so dumb, we don't know that. And that's how they play with your head. And lawyers go along with it, because maybe some of them believe it anyway. The current judgment would have to be appealed to the Privy Council or the House of Lords of the Privy Council, the last court of any appeal. So the Privy Council is the last court we could go to, and we're not going there. At least we're reserving that. And unless the only party that could appeal is not doing so, then not even the Privy Council could have jurisdiction to hear the matter. This means only legislation could remedy this judgment that brings so many benefits to homeowners who purchased under the illegality or the illegally operating developers, including the NHG and their developments. Meaning all previous agreements would still be illegal, and therefore any agreements coming out of them are unenforceable. In other words, the government and the banks or your mortgage lenders would have to absorb any losses to them. And because your payments to them were illegal, then it is their responsibility to pay you a refund and interest on the funds previously collected from you, of course. Find other persons who reside in your community, especially if you reside in one of the mass housing developments. Pool your resources to find a lawyer or lawyers to file for an injunction against any further collections, in addition to file a complaint for a refund and interest on your money. So in other words, don't just sit down until they pull a stunt and make some rule and then say, oh, you didn't act on it when the law was changed, so you and go and come with some statute of limitation and create one that will block you from going to get your money back or stopping them from collecting. You need to act now. Stealth is important when you're trying to take advantage of anything. If you delay or drag your feet, then they're likely to find a way to take it from you. So find lawyers, pool your resources. You one can come up with the money, find a bunch of people in your community who want to take advantage of this, keep the money in their pocket, and even have these people paying you back some money with interest, and have them test the thing in the courts. You have nothing to lose. A couple of you put money together, get an attorney to file a complaint. So find other persons, as I said, who reside in your community, especially if you reside in one of the mass housing developments. Pool resources to find an attorney or attorneys to file for an injunction against any further or future collections, in addition to file a complaint for a refund and interest on your money. Now, if you can find a whole bunch of people, don't use one attorney. Break up into groups and have multiple attorneys file multiple claims. This way the court can't just dismiss one and dismiss all. They have to look at everybody, and when they see the masses of attorneys, sometimes they'll hesitate to play the games they play, because there is a judgment already in your favor. In short, the court already ruled in your favor, so it's going to be difficult for any court to not take your matter or hear your matter. I'll get you that injunction because the appeals court ruled on it, the Supreme Court already ruled, the appeals court already ruled, and we're not appealing it. So it's enforceable, and it's enforceable from the date they made the ruling, both the Supreme Court and the appeals court. So your money that they should be paying you should be retroactive from the time the act went into being, and they're collecting your money over whatever period of time. So because there's a judgment already in your favor, March 31st, 2023, by the appeals court, you nor your attorney should have any major hurdles landing an injunction on stopping your monthly payments to lenders or banks. Make sure you get an attorney to first represent you on the benefits coming out of this ruling, and not one who is corrupt and will sell you out under pressure from the bank, NHT, real estate board, and even the government. So be vigilant and be aware and be conscious, and don't act the fool. Don't go in there and keep your mouth shut when you have an attorney. You tell them what you want. You hire them, you're paying them, they work for you. Just like these people in government. We have to drive the message home. You work for us. People in the courts, they work for us, and they must run according to the Constitution, not what they feel like. If they want their own country, go to sea and find an island and go live there. But you don't come into a court of law in a country with a constitution and then you try to make your own rulings that affect people's rights under the constitution legally. Now, a lot of people don't recognize this fact, but the constitution is a contract. The constitution is a contract between the individual, the majority, and the government. And what that contract is saying, if the individual that falls under this constitution performs or acts or obeys or complies with the constitution, it means the courts will enforce protection of these constitutional rights, even if the majority of the people out there object to it. In other words, the Constitution is saying you do the right thing, the court must protect you from the majority if the majority is trying to hurt your constitutional rights. That's what it means. Simple and straightforward. So this whole idea of going in there and screwing up people's lives and individuals and stepping on them because the rest of the people don't know what's going on is wrong, and judges know better. As I said, study the Constitution and the constitutional laws. Then I went on to list a few things for professional organizations, and I'm going to be quick. And this is saying for professional organizations and or trade unions representing masses of workers, this applies to you, and you must exercise your responsibility in protecting the financial interest of your members by doing the following. Each organization to retain its own lawyer. So 200 or 300 don't get together and use the same lawyer. Get different lawyers for each body. Each organization to file its own complaint, and this should be a fixed date claim or complaint, since money deducted or paid from your member salaries or income are in fact property, and they are subject to the property rights as guaranteed under the Constitution. And the reason I say it's a fixed date claim is because under the rules of the court, anything that has to do with property and you're filing for property, it's a fixed date claim. And that is good because it will bring that matter in front of the court in an earlier date time if they comply to the rules. So we file stuff, and when it should have been in front of the court, it's still not there after decades. In other words, make sure you include constitutional rights issues beneficial to your members that were violated by the illegal collection and the forceful possession of property of your members. And the forceful possession is the statutory deductions when they pull your NHT and they force those money out of your money, your salary and accounts when they didn't have a real estate dealer's license. In short, make the argument, lawyers. Find every argument you can make and make every one of them, because they'll have to overcome all of those. And you're doing it to really enforce the judgment of the appeals court. However, you're doing it because you want to say, beyond the judgment of the appeals court, our people are entitled to compensation for the things you did to us. You damaged us. You took our money when you shouldn't have taken it. We could have taken our money, go buy something, build something, invest it, and make more money on it. You have our money working, and in fact, you have our money lending government to go build other things and do other things when I have nothing to do with housing. So you need to compensate us. So those are the arguments you want your attorneys to go in there. Get attorneys who have fresh brains and not willing to step into new territory and set precedences. Give the arguments that's going to make your case as strong as possible. So talk to that attorney and say, if you can't deliver this, just don't take with money, and then go in there and set us up, because if you do that, we're going to come after you, going to sue you behind as well. In other words, make sure you include constitutional rights and issues beneficial to your members that were violated by the illegal collection and forceful possession of property of your members. A constitutional plea will also make it legally impossible for the court or any corrupt judge to simply dismiss your members' claim on summary application, bogus or legitimate. And I'm saying that because the rules of the court say constitutional issues and defamation aren't dismissible by summary judgment. And summary judgment is when a lawyer make up some argument, legit or not, if it's in the right situation, and present it to the court and say, this case shouldn't go forward because of XYZ. If it's a constitutional issue or it has to do with defamation, then the court, by its own rules, can't dismiss it on summary judgment. But they'll try to find other tricks, like I said, come up with technicalities where the judge can now sanction you and strike your claim by saying, oh, we sanction you because you didn't do this, that. It's a backdoor they're using to get your case off the roster, even when the Constitution and the laws of the court, the rules of the court, say it can't be dismissed on summary judgment because of constitutional issues. So they create a way to get it dismissed by saying, oh, sanctioning you until you get relief from sanction, and you never hear that case called up again. You file to get relief, it takes years for it to come up, if it does come up, and it's because you're pressuring them. Make sure your attorney asks for a jury trial of the matter. And if it's possible, I don't see too many jury trials in Jamaica, but I'm pretty sure you're entitled to a jury trial. And if it's on criminal matters, guess what? This is a criminal matter. The illegalities, the contracts involved, the law, they're breaking the law. So it's a criminal matter. So if they were to say, oh, juries are only allowed on civil matters, this is not merely a civil matter. This is a criminal matter, because it involves people breaking the law and collecting money from you illegally. And as the judgment said to me, you're lucky you're not in jail and not facing good for nothing low life scumbag Williams going to say, oh, not yet. You know, no lawyer should go in and try to deal with people like that. You don't have that right. But there are consequences, and I said, be very careful who you approach like that. Nobody go and put up with all of that foolishness. I'm one of them. So when you're in front of the court, regardless of where this person come from, their station in life, you don't go in there and try to insult them. That's because help to be paid for people who won't sit down and take that. They're going to pay you back. And justly, you don't have any right to go in and insult people. Do your job as an attorney. Go in there, deliver the facts, deliver the law, deliver your evidence, and let the ruling go where it should based on that. Don't try to diminish people's character or their situation or station in life because you feel you're so big, because you have a law degree. A law degree is simply a piece of paper that gives you authority to go in and represent somebody else, nothing else. Alright? You know, use it to cheat people and thief people and undermine the country, corruption and breed corruption like crazy. But all you have is a piece of paper that says this paper allow you to go in a court of law and represent these persons if they want you to. Because the Constitution and the rules of the court, the Constitution especially, said the person can take anybody they want to represent them in court. So in truth and in fact, under the Jamaica Constitution, they don't even need you. So don't drive the message home that people need attorneys to come into court. What we need is for the courts to write the rules of the court and the laws of the land, parliament, so that anybody can understand it. So anybody with a brain that deals with logic and understand logic and common sense can represent themselves in court, or anybody else that wants to represent them. So this whole idea that you need an attorney in court, no, you don't. People push you to get one because you had to deliberately write the laws in such a convoluted way to fool you and to scare you. But the reality is, if they write the laws so everybody can understand it and it's simple and straightforward, then people aren't mandatorily required on the law to have an attorney. They can represent themselves or be represented by anybody they select. And again, don't take my word for it. Go to your Constitution. Look on the due process. The Constitution, read the whole Constitution, as a matter of fact. Don't just stop at certain. Read the whole Constitution and learn your rights. Because when you don't know those rights, people go in there, especially these judges, and take advantage of you. And these attorneys, because the attorneys will go in there and don't even have an argument to back up what they're saying. And the judge will come with some nonsense. Like I was in there recently, and the judge is going to tell me, oh, the Jamaica court hasn't gotten to the stage where you can represent somebody. That's what she said to me in the appeals court. So knowing me, I don't typically jump up and say anything until I have the facts. So immediately I know better. I ran and checked the Constitution. And the Constitution say the person can select anybody they want to represent them. So when that judge makes that statement, is it that she's ignorant of the Constitution? Is she trying to fool me up? Is she trying to make an ass of me or an ass of herself? But the fact is, she's ruling against the Constitution, which is not allowed. But I'm saying this to you: learn your Constitution. And when you know your rights and your Constitution, and you're going to any place, anywhere you go in the world, any part of the world, any branch of government, anywhere, they can talk to you any way. And if they do, you put them in a place. And that's how you assert yourself as a human being. You have rights. Don't let people take your rights and step on it, because that's when they treat you like dirt. And the more you accept the foolishness, is the more they wipe their feet on you. And worse. Alright. Alright, make sure your attorney asks for a jury trial. So I'm going to be quick. Ensure that no payments are collected from your members so that they have access and use of their money that will now be available to them because they are not making these monthly payments. Use this opportunity to also strengthen your bargaining power for improved benefits for your members. Example, use the fact that government allowed your members to be illegally billed by illegal contractors and developers, and any agreements associated to demand repayment of illegally collected funds. So you see, you can't get paid, they're holding back your money, all of that stuff. Use this opportunity to say to government, based on these illegal activities of various government entities and what the court is saying, and the fact you're collecting our money in NHT and using it for illegal means, because that's not what the NHT Act was about. Take those funds and use it to pay the benefits that you say you can't find money to pay nurses and teachers or police. Pay it from that, borrow it from that, and then find ways to pay it back into that so that you can satisfy the salary demands of these people so they can have a living wage. Again, if you can use the NHT money for do everything else, why don't you use it to create methods of paying people? In other words, you can use it as a tool. What's happening here is a tool to negotiate. Use it to negotiate other things as well. Don't just stick to one. But it puts you in a strong position with government, because ultimately government is responsible. And the other thing is, if all your members decide to go slow because of what's happening with this thing, or strike because of what's happening to these things, they'll make sure they fix it quickly so that you know that they can't come after your property or your house or whatever as part of a settlement if we get to that stage. But according to the ruling, there should be no settlement or debate about your rights. But again, if they try to play tricks, you're in a strong position to say, guess what? All of this was illegal, so if any amendments are being made to the law, it must be made that the homes that you now possess cannot be repossessed by the developers or the banks, because all of those activities were illegal, and anything to take property from you now is illegal. And the other thing is, if you've owned that property for more than 12 years under the Constitution, they can't take it anyway. Because remember, the money that they've been collecting from is illegal money. So they can't say, oh, well, you've been paying this bill, and because you've been paying it, the 12-year period doesn't apply. The money you were paying was money that was illegally collected. It's as if you never paid any money towards this property. All right? Because everything is illegal. So technically, no money was paid towards this illegally built house, in this illegally drafted agreement, this illegally granted loans. So they can't come say it was legit money, so we're going to apply it to the statute of limitations when it comes to the 12-year period. If it's illegal, government and the courts can't use it to enforce in favor of anybody. Alright? So, based on my interpretation, you're in a strong position to negotiate for those properties if the question should arise, and use it to build your real estate portfolio. As I said, when you get advantages in life because of mistakes that's made in the courts or by parliament, take it. Take it and use it to your advantage. And that's what you do. Okay. Most importantly, have your members relocate their money in banks to institutions that do not have a strong loan or mortgage portfolio. Dealing with mortgage payments, and to an institution such as a strong credit union for additional financial benefits, while protecting their money from vindictive banks or banks that could now fail as a direct result of the rulings. So in short, make sure you know how you manage your money, because if I have money in one of these banks and I know they have a lot of loans out there, mortgages out there, mortgage payments to come into them, and it's going to stop, then it's going to affect them and their stability. So money I have in a savings account, if I had a savings account, I would take my money out and put it in a credit union that doesn't deal in a lot of mortgages and they're very strong. Make it sit there, because when it's sitting there, it means you can, after I think 6 months, access 3 times what you have in that account. And accessing that money in triplicate means you can leave your principal there, take 2 of it, invest it in something, buy something, go on a trip, enjoy money, let the money work for you. All right? So become astute thinkers and not just sit down and accept everyday action. In other words, you should also sue all government agencies that allow this unfortunate situation to arise. These government organizations would include NHT, the Real Estate Board, the ministry that's responsible for NHT, not NHT, even NHT and the Real Estate Board, and I think that's a ministry in the Prime Minister's office. And sue whosoever you need to sue to make sure they know you're out there and you're aggressively pursuing your own right to protect your interests. Your attorneys, in fact, you can probably sue the Attorney General, because I think the Attorney General is responsible for the actions of the court, or the court. Have your attorney look into everything. Your attorney should also look at filing suits against banks and other financial institutions for making election collections from your members, and therefore your members are now demanding a refund or interest. In short, go after the bank before the banks come after you. Sue them, because they gave you or entered an illegal agreement, gave you an illegal loan. The money they were collecting is like extortion money. In short, it's illegal. So they're either going to pay you back with interest or whatever. But the fact is, you need to sue them before they sue you. And I can be reached at the YouTube channel Scamming Billions in Jamaica 6208 by leaving a note in the commentary section, or my email, which I gave in a letter. Also see attached notice to the real estate board for their immediate attention. I have not received any correspondence from them to date. So in short, these people have gotten the information. They know about it. I've sent this out to organizations that protect or work for workers or employees. So everybody's getting the information. I'm asking you to not only listen again, watch the video and share it and subscribe. Ask anybody who comes to the channel, just take time to subscribe and share it. Send it to other people. But reach out to people you know that might have property there, that might not have property there. Tell everybody, say this is happening. You need to pay attention to it so that we can have serious changes in how these government entities and the courts function, and so that we protect our economy and our country in the long and the short run. Thank you for taking the time. I'm going to close out now. Hopefully we'll be talking tomorrow. I'll update you as to what's happening on this and on the other matters dealing with Capital One and their corruption and what the courts are doing there as well. But we're doing some legal transactions that I want to pretty much kind of keep on the down low until we achieve those objectives. But we're not sleeping on the job. All right, thank you. Don't sleep on yours either. Be alert. Take advantage of matters that benefit you and your family. As I said, look in the mirror. Hug yourself, hug your family, keep them close. All right, have a great one.